Hello, I'm Walter Haines with United Employees Law Group. This message is one of a series designed to expose common errors and violations engaged in by companies that have shortchanged employees out of tens or even hundreds of thousands of dollars in overtime pay and related violations. Having prosecuted well over 700 labor cases, of which more than 70 were class actions against Fortune 500 companies, we discovered that most of these errors and abuses went unchecked over time because employees counted on their employers or the government to protect them. Unfortunately, this has allowed some employees to suffer major losses. We at Employees Law Group have created this series to help you recognize some of the common violations we have prosecuted. This series is designed to give you insight on your employment rights. The following discussion covers the administrative exemption, which in many instances has been used improperly to deny overtime compensation. It is also unlikely that your employer will even advise you as to which exemption is being applied to deny you overtime. And if it does, multiple exemptions may be applied to add to the confusion. Because of the complexities and the subtleties of the administrative exemption, it is difficult for an employee to know if his or her employer is applying the law correctly. The key here is to know when to seek an unbiased analysis of your situation. There are 6 mandatory requirements that an employer must meet before the administrative exemption can be used to deny overtime. Keep in mind that if just one of the 6 requirements is not met, then this entire exemption fails and overtime must be paid unless a different exemption applies to your job and all its tests are satisfied. Number 1, salary must equal at least twice the minimum wage. Number 2, the type of work cannot be manual in nature, such as physical hands-on type of work. Number 3, the work must directly relate to management policies or general business operations of the employer or the employer's customers. Number 4, the employee customarily and regularly exercises discretion and independent judgment on the job. In general, the exercise of discretion and independent judgment involves the comparison and the evaluation of possible courses of conduct and acting or making a decision after the various possibilities have been considered. Handling matters in accordance with prescribed company policy does not meet this requirement. Number 5, the employee must regularly and directly assist a proprietor or another employee who is employed in a bona fide executive or administrative capacity, or the employee performs under general supervision, works along specialized or technical lines requiring special training, experience, or knowledge, or the employee executes under only general supervision, special assignments and tasks. 6, the employee must be primarily engaged in exempt duties, which includes managerial responsibility, where the employee has personal effect on the policy or general business operations of his employer or its customers. In reading through some court cases, I came across a simplified explanation that is helpful. The judge said, the employee must be engaged in running the business itself or determining its overall course or policies, not just carrying out day-to-day business affairs. Putting it more simply, there's a difference between one who merely works around the place and one who has something to say about running the place. One other critical piece is the amount of time the employee spends on administrative duties. If the employee also helps out in other areas that are not administrative tasks, and he does so for more than half the time, then he is not exempt. If you suspect you have been misclassified, take a couple of minutes to talk to an experienced California labor law attorney and find out what your rights are. This video is part of United Employees Law Group's effort to provide useful information and strategies to protect your rights and to level the playing field. Thank you, and I invite your comments.